You know, when you see a massive billboard on the side of the highway, it's designed to give you this single, incredibly simple message in like 3 seconds.
Right, yeah, barely 3 seconds of passing time.
Exactly. It's built to be digested instantly at 70 miles an hour.
I mean, buy this product, vote for that candidate, take this exit. The whole medium is engineered entirely for speed. It's not for nuance.
It's really not. But if you were to, say, actually pull your car over to the shoulder, get out, walk through the grass, and stand right under that billboard to read the tiny legal fine print hiding at the very bottom.
Which nobody does, by the way.
Right. Nobody does it. But if you did, suddenly that simple message isn't so simple anymore. What looks like a flashing green light from a distance is, well, it's actually a highly conditional yield sign when you get up close.
Oh, absolutely. And that gap, that huge gap between the giant bold font and the tiny legal text, that is what actually governs your life in the real world.
Which is exactly why we're here today. We are diving straight into that exact gap, untangling the highly complex web of Florida's recent gun legislation. We've got a brand new deep dive for you today, focusing on a really detailed breakdown from Valortec.
Yeah, they're a prominent Florida firearms training academy. The source we're using is their analysis from July 20, 2026.
Right. And, it is so crucial to establish the parameters of this deep dive right away. Because the stakes for the average citizen navigating these statutes are, they're incredibly high.
They really are. A misunderstanding of the law here isn't just a lost debate on social media. It can literally mean accidental felony charges.
Exactly. So I want to be absolutely crystal clear right out of the gate here. We aren't here to take a political side on gun control or Second Amendment rights. That is not our job.
Right. Definitely not.
Our job today is purely to report on what the source material lays out. We're decoding the legal reality versus the political rhetoric, just so you know exactly what these laws actually mean.
Impartially, just looking at the facts on the ground.
Exactly. And here is the hook that really grabbed me when I was reading through the Valortec source. Over the last few years, millions of people across the state, and honestly the whole country, they celebrated, they protested the arrival of constitutional carry in Florida.
Oh yeah, it was massive news.
But according to the legal and tactical experts at this academy, that's not actually what the legislature passed.
No, not even close. The gulf between what was advertised to the voting public and what was actually written into the Florida statutes is vast. Bridging that gulf,
Yeah.
it has to start with getting the vocabulary right.
Because words in a legal context have incredibly strict definitions.
Exactly. So let's unpack this. We have to start by establishing the baseline of what actually happened in Tallahassee versus, what was printed on the campaign signs.
Okay, let's unpack this. House Bill 543 took effect on July 1st, 2023. The public enthusiastically called it constitutional carry, right?
Yeah, that was the slogan.
But the law itself actually allowed for permitless concealed carry, meaning a person no longer needs to obtain a Florida concealed weapon or firearm license, the CWFL, before carrying a hidden weapon.
And that word right there, concealed, is doing a massive amount of heavy lifting. The 2023 law was very specific in its scope. It was entirely focused on firearms hidden from common sight.
Right. The way I was thinking about it as I read the source material, it's like removing the toll booth on a highway, but explicitly keeping the speed limit.
Oh, that's a good way to put it.
Like you don't have to stop, pay a fee, or show your pass to get on the road anymore. But once your tires hit the pavement, you still have to follow every single rule of traffic.
That is a highly accurate, very mechanical analogy. Let's look at exactly what the law removed. The toll booths, as you say.
What went away?
Well, the legislature eliminated the advance application process. They removed the requirement to submit your fingerprints to the state government. They erased the licensing fees, the formal training documentation, and the agonizing waiting period for the Florida Department of Agriculture to actually process and approve you.
All that friction just vanished.
Yep, all of that friction went away.
Which, to a casual observer, that feels like a complete deregulation. It sounds like the state just threw its hands up and walked away.
It definitely projects that image, yes.
Mm-hmm.
But let's look at the speed limits that remain actively enforced. Because the law absolutely did not erase the restrictions on where you can physically go with a firearm.
Right, the location boundaries.
Exactly. Permitless carriers are subject to the exact same prohibited location restrictions that apply to official license holders. A courthouse is still a courthouse, right? You cannot carry there.
That didn't change.
Nope. You can't carry in police stations, schools, polling places, Government meetings, the sterile areas of airports past the TSA checkpoints, or, the portions of bars and restaurants primarily devoted to serving alcohol.
But hold on, let me push back on the logic there for a second. If the law explicitly says you don't need a permit to carry, doesn't that inherently mean anyone can carry anywhere?
I see where you're going with that.
Doesn't the lack of a permit requirement just blanket authorize the general public?
What's fascinating here is how the specific wording of the statute functions. Like, under the hood. Florida statute section 790.01 does not simply declare that everyone has the right to carry.
Oh, it doesn't.
No, it's written as a conditional statement. It very specifically states that an unlicensed person may carry concealed only if they meet the strict eligibility requirements found in an entirely different section, section 790.06.
Okay, so the prerequisites still exist in the code. The state just isn't checking them at the front door before you leave your house.
Precisely. The burden of proof just shifted from the state's processing desk to your shoulders out in the real world. You are still required to be legally eligible.
Meaning no criminal history.
Right. No disqualifying criminal history, no active domestic violence injunctions, no involuntary commitments to mental health facilities.
Oh, okay.
And carrying a concealed firearm while you are legally ineligible. That isn't treated as a minor administrative infraction. It can still be prosecuted as a third-degree felony.
So the stakes are just as high.
Higher, maybe, because you don't have the state double-checking your work.
Right.
Plus, the statute mandates that if you are carrying without a permit, you are legally required to have a valid state-issued ID on your person.
Oh, really?
Yeah, and you must produce it immediately if a law enforcement officer demands it. The Valortec source puts it very bluntly, and I think it frames the reality perfectly. They say a firearm is not a permission slip to act stupidly.
I love that line. The legislature removed an administrative bottleneck. They didn't repeal the criminal code. So in 2023, the legislature delivered permitless concealed carry, leaving the open carry ban strictly in place. But, you look at Florida today, and the reality looks a whole lot more like true constitutional carry.
Yeah, it really does.
You see people openly carrying in certain contexts without being arrested. How did that happen if the legislature didn't actually pass it?
Because the state's legal landscape dramatically shifted 2 years later, in 2025. But this evolution didn't happen in the legislative chambers in Tallahassee.
It happened in a courtroom.
It happened in a courtroom, yes.
Right, because true constitutional carry, as it's generally understood across the country in places like Texas or Arizona, that includes both open and concealed carry without government permission.
Exactly. And in September 2025, the judicial branch forcibly stepped in where the legislature had compromised. We saw a pivotal, landscape-altering ruling from Florida's First District Court of Appeal.
This was McDaniels v. State, right?
Yes, McDaniels v. State. The appellate court examined Florida's categorical ban on open carry and ruled that prohibiting peaceful, law-abiding adults from visibly carrying a firearm was a direct violation of the Second Amendment.
They just struck down the blanket ban.
Effectively, yes.
Which is a seismic shift for law enforcement on the street. I mean, totally game-changing.
Utterly seismic. Because following that appellate decision, the Florida Attorney General had to issue immediate binding guidance to prosecutors, sheriffs, and police departments across the state.
Saying what?
That guidance advised them not to arrest peaceful, law-abiding citizens simply because a firearm was visible on their hip. That specific court decision is what actually pushed the state into a functional system that resembles the constitutional carry slogans.
Okay, but let me challenge that premise for a second. If the Attorney General says open carry is protected now because of this court ruling, doesn't that mean those original campaign slogans from the politicians were basically right all along? Like, why does it matter to you or me if this freedom came from a judge's gavel or a legislator's pen? The end result is the same, isn't it?
This raises an important question about how citizens actually navigate the justice system in real time. It matters immensely because of the profound danger of a fragmented legal framework.
Fragmented?
Yeah, if a state legislature passes one clean, comprehensive, constitutional carry statute, all the definitions, boundaries, and specific exceptions are neatly contained. They're cross-referenced in one cohesive document. Everyone is reading from the exact same page. But that isn't what Florida has. Florida has a patchwork.
Right. It's like a software program where the code was written by three different developers over 3 different years, and none of them used the same programming language.
That is a brilliant way to conceptualize it.
Yeah.
You have the 2023 Legislative Act strictly covering concealed carry.
All right.
You have much older statutes defining the complex baseline of legal eligibility. And now, layered on top of all that, you have a 2025 appellate court decision carving out protections for open carry.
That is messy.
Relying on a campaign slogan rather than understanding this patched-together code that can lead to catastrophic, life-altering misunderstandings for a citizen.
Because the friction happens in the real world, out on the sidewalk, not in a courtroom.
Right. Imagine a scenario where a citizen assumes they have blanket, untouchable immunity because a politician tweeted, "constitutional carry." They might openly carry a rifle into a restricted zone or act aggressively during a traffic dispute, completely misunderstanding the delicate nuance of the McDaniels ruling.
Because the ruling had caveats.
Heavy caveats. That court specifically emphasized peaceful and law-abiding behavior. The Attorney General's guidance explicitly warned that this judicial right to carry does not protect menacing, threatening, or brandishing conduct.
So if you don't know exactly where the court drew the line, you are literally risking your freedom on a guess.
Exactly.
Okay, so if the state and the courts have stripped away all these upfront legal requirements to carry, that leaves a massive vacuum. The state isn't verifying your paperwork anymore, which fundamentally means they also aren't verifying your competence.
Oh, this is the big one.
Right, here's where it gets really interesting, because the most controversial feature of this new legal reality isn't about the courts or the legislature at all. It's about the practical reality of training.
Yes. The elimination of the training mandate completely changes the tactical landscape of the state.
Valortec really highlights this void in their breakdown. Under the old licensing system, before 2023, there was at least a requirement to prove you had some meaningful training before you could carry a hidden gun in public. What did that actually look like mechanically?
To be perfectly fair, firearms instructors widely consider the old system's requirement to be a very low bar.
Like, how low?
Well, to get the license, applicants essentially had to provide documentation proving that a state-certified instructor physically observed them safely handle and fire a handgun with live ammunition.
So it wasn't exactly elite Navy SEAL tactical training.
Far from it. In many cases, it was firing a single shot into a barrel in a highly controlled environment.
Wow, okay. One shot.
But, and this is crucial, it was something. It was a minimum physical checkpoint. It proved that the person had at least felt the recoil of a real firearm and demonstrated basic trigger discipline to a professional.
And permitless carry completely erased that minimum checkpoint.
Entirely. Now, no one is legally verifying if a person carrying a loaded weapon in a crowded grocery store has ever actually drawn a gun from a holster safely. No one is checking if they know how to clear a complex malfunction under stress.
And beyond just the mechanical operation of the gun, no one is verifying if they understand the laws of self-defense, right?
Exactly. And that is the most dangerous void. The state is no longer verifying if a carrier understands the vast critical legal difference between someone insulting them over a parking spot and an actual, lawful, deadly force situation under Florida's Stand Your Ground laws.
It makes me think about buying professional equipment, like buying a fancy $5,000 camera doesn't make you a professional photographer.
Right, you still have to know how to use it.
Yeah, it just means you own a complicated machine. You still have to know about aperture, lighting, and composition. The source material says it so perfectly, and this quote really stuck with me. A right is not a skill. A gun is not a judgment machine. And permitless carry does not download competence into the owner.
That quote is just, it perfectly encapsulates the sheer mechanics of violence and self-defense. A machine requires a skilled operator.
Right.
Drawing a firearm under the massive adrenaline dump of a life or death encounter requires deeply ingrained muscle memory and split-second legal processing. The state has effectively declared that it will no longer verify the operator's competence before they walk out their front door.
But, isn't the whole underlying philosophy of these types of laws that the state assumes the individual will take personal responsibility? Isn't the idea that it's inherently on the citizen to train themselves, rather than forcing the government to act as a nanny?
Yes. Philosophically, the law inherently assumes that the mantle of responsibility will be eagerly taken up by the individual.
But does that happen?
Well, the Valortec source issues a very stark, realistic warning based on human nature. Some people will absolutely take that responsibility seriously, but many simply will not.
Right. People are people.
Exactly. Valortec points out that pretending an untrained person is magically prepared for a chaotic, violent encounter just because carrying the gun is suddenly legal is intellectually dishonest. Removing a legal barrier by legislative decree is not the same thing as removing a personal standard of safety.
The state backed out. They didn't make the citizens better shooters.
Spot on.
So we've established that the legal minimum isn't nearly enough to guarantee real-world competence. Which brings us to a really fascinating paradox here.
Let's hear it.
If I am a legally eligible, law-abiding gun owner in Florida, why on earth would I voluntarily jump through government hoops, get my fingerprints taken, pay a licensing fee, and wait for bureaucratic approval to get a plastic permit that I technically no longer need?
It is a great paradox. Why submit to the state when you don't have to? And the answer is that the little plastic card still carries significant legal weight. It primarily acts as a passport across invisible borders.
Okay, so what does this all mean for the citizen trying to do the right thing while navigating this patchwork? The source groups several of these administrative benefits together, and it seems like the biggest traps involve crossing lines you can't even see.
Absolutely. Think about the friction of moving through physical space. Florida's permitless carry law is just that Florida's law.
Right.
It abruptly stops the very second your tires cross the state line. If you travel into Georgia or Alabama, states that officially recognize Florida licenses, having the actual physical CWFL card gives you immediate legal cover.
But without it.
Without it, relying solely on Florida's permitless carry, you might inadvertently commit a felony the moment you drive into a neighboring state that demands a formal permit.
Wow, so your constitutional rights don't vanish, but the other state's criminal statutes suddenly apply to you. But this invisible border issue doesn't just happen on interstate road trips, right? The source details an incredibly technical trap regarding federal law right in your own neighborhood.
If we connect this to the bigger picture, you see exactly why Valortec is issuing these dire warnings. You are referring to the federal school zone exemption. Under federal law, it is generally illegal to possess a firearm within 1,000 feet of a school.
And 1,000 feet is massive in a city. That's over 3 football fields.
Oh, it's huge.
You could be driving down a main arterial road in Orlando and never even see the elementary school tucked behind a row of businesses, and you are deep inside that zone.
Exactly. It creates a massive, invisible, overlapping web across any urban or suburban area. But here is the mechanism that saves you. The federal statute has a specific, hard-coded exception for individuals who are formally licensed by the state where the school is located.
Oh, I see.
Because the state permit requires a background check that meets federal standards, the CWFL acts as a federal exception. Permitless carry does not meet that standard.
Wait, so a citizen could be perfectly legal under Florida's permitless carry law, unknowingly drive through one of these invisible 1,000-foot zones, and suddenly they're committing a federal crime.
Exactly that.
That is terrifying. It's a jurisdictional trapdoor. And this applies to actually purchasing firearms too, doesn't it? I know Florida has a mandatory waiting period for retail sales.
Right, that's another critical administrative benefit. Florida imposes a mandatory 3-day waiting period for retail firearm purchases to act as a cooling-off period.
Yeah.
However, if you hold a valid active CWFL, the state recognizes you've already been thoroughly vetted.
So you skip the wait.
You are legally exempt from that waiting period, yes. If you only qualify for permitless carry, you have to wait. The license cuts through the red tape.
Which makes sense. It's an official administrative stamp of approval.
And that stamp of approval is vital for state eligibility determination. When you apply for the license, the state runs your fingerprints through the FBI database and conducts a deep dive background check. When they issue the card, they're officially confirming that you are legally clear to carry.
Whereas permitless carry.
If you just rely on permitless carry, you are doing the legal guesswork yourself. You are assuming that a complex, withheld adjudication on a charge from 20 years ago doesn't disqualify you today. The permit completely removes that dangerous guesswork.
It essentially serves as a definitive legal shield.
It does. And finally, taking the affirmative steps to get the license sitting through the class, submitting your fingerprints to the state, subjecting yourself to the background check. It establishes a documented baseline of intent.
Showing you're serious about it.
It shows a commitment to being a responsible, educated, armed citizen. This is why the source heavily cautions against relying on the legal advice of social media experts wearing wraparound sunglasses.
I love that quote. It perfectly visualizes the loudest, least informed voices on the internet.
Exactly. The CWFL doesn't magically make you John Wick. It doesn't upgrade your physical aim or grant you elite tactical awareness.
Oh.
But actively rejecting this incredibly useful legal shield just to stubbornly prove an ideological point about your constitutional rights is, well, as Valortec notes, stubbornness disguised as principle.
Wow. Stubbornness disguised as principle. That is a brilliant distillation of the entire issue. So, to synthesize this massive web of information for you listening, the state of Florida fundamentally lowered the legal barrier to carrying a concealed weapon in 2023.
Right.
And then the judicial branch stepped in to strip away the ban on open carry in 2025. But this newfound administrative freedom did absolutely nothing to erase the massive standard of personal, legal, and tactical responsibility that is now placed squarely on the shoulders of the individual citizen.
Nothing at all.
The minimum legal requirement to carry a gun is just the starting line. It is absolutely not the finish line.
It really forces us to look past the individual statutes and examine the broader cultural implications of these laws, which leaves us with a critical, somewhat unsettling thought to ponder today.
That's it.
If expanding a legal right inherently removes the government's role in verifying the skill required to exercise that right safely, how do we, as a culture, enforce the invisible burden of personal competence?
Mm.
When the law deliberately steps back, what exactly is supposed to step in to ensure that a society of legally armed citizens is also a society of capable and responsible ones?
That is the ultimate question at the heart of all this. It's about what happens when you finally read past the giant text on the billboard and realize the fine print is entirely up to you to write. You've been given the green light to drive, but you are the only one controlling the brakes. Thank you for joining us for this deep dive. Keep questioning the slogans, keep reading the fine print, and keep seeking the why behind the headlines. We'll catch you next time.